And now I'd ask Barrister Salahuddin to come and speak. And I mean, of course, he can speak about the Pakistan experience, given his involvement in seminal political cases or cases where we've seen difference of opinions or polarization.
Thank you. It's a pleasure to be here at the Asma Jahangir conference again. The topic at hand is contradictory decisions. I was reminded of an interview of the late Zulfikar Ali Bhutto, Prime Minister of Pakistan, with an Italian journalist, Oriana Fallaci, who asked him why he made so many contradictory statements. And he, in reply, he quoted the American philosopher, essayist, Ralph Waldo Emerson, that a foolish consistency is the hobgoblin of little minds. The full quote of Emerson runs that it is the hobgoblin of little minds adored by little statesmen and philosophers and divines. With consistency, a great soul has simply nothing to do. He may as well concern himself with his shadow on the wall. Speak what you think now in hard words, and speak tomorrow what tomorrow thinks in equally hard words, although it contradicts everything you say today. Now, another Prime Minister of Pakistan expressed a similar view with perhaps a little less flair, that a leader who does not take U-turns is no leader at all. Now, like politicians, poets are also similarly untroubled with contradictions. Rather, they embrace that conflict within themselves and they make it a fertile field for their creative expression. As anyone who tries to pigeonhole the ideology of Allama Iqbal from his poetry. Now, perhaps the American poet Walt Whitman put it best, that do I contradict myself? Well then, I contradict myself. I am large, I contain multitudes. Now the question is, do we want our judges to be great men, or do we want them to be little men, hemmed in and locked in by the law? Are we willing to give them the same creative license that we are willing to afford poets or political leaders? Are we right to demand a greater consistency from them, a greater logic from them? That is what we are here to discuss today. Now, starting from the topic, which is eroding the rule of law and conflicting legal decisions, first let's pass the rule of law a little bit. Now, the rule of law has many components and we can't possibly go into them here. There was an excellent article the other day I read by Rima Umar, in which she encapsulates 8 components of the rule of law. Now, one of them is consistency. Now, there should be consistency in the law itself and necessity and of supreme popular public welfare to justify military rule. The Supreme Court took a step forward. It was a conflict. It was a positive conflict. Similarly, when the Supreme Court today has struck down military courts, which earlier it had said trials of civilians in military courts is okay, when it took the step that no, it's not okay, FB Ali was wrongly decided, I think that is a positive development. The problem is that you have to squarely confront the previous jurisprudence. The problem arises when the Supreme Court does not face up to the previous jurisprudence. It just ignores earlier judgment. Requires a certain degree of cooperation and self-restraint from judges as a group. They are responsible for interpreting laws and they are responsible for applying those laws. For us to have any kind of consistency in both the law and the application of law, they have to be willing to sacrifice their individual creative impulses in favor of collective certainty. That over your hands to be tied by past legal precedent and sometimes being forced to reach decisions that go against your personal sense of morality, right or wrong, or even justice. Now, a poet who lets his individual expression be hemmed in that way, now that would be a mediocre poet. But a judge who lacks the self-discipline to do exactly that, that judge is in the wrong profession. Now, don't get me wrong, I'm not advocating that there should be an absolute rigid adherence to past legal precedents. Something that allows for no room for creation of new jurisprudence. At one level, conflict, dissent, these are essential, these are the fields from which judicial progress, jurisprudential progress happens. If we just all faithfully followed precedents, it would condemn our todays and tomorrows to the clutches of the dead hand of the past. But nonetheless, there are good conflicts and there are bad conflicts. I'd like to talk about those a little. Now, firstly, the good conflicts. There is the healthy conflict that takes place within a judicial decision itself, where judges on a bench disagree or dissent with a conclusion owing to different interpretations of the law. This kind of conflict only stimulates a deeper and more holistic understanding of the law, and it allows the jurisprudence to move forward. A classic example perhaps is the decision of the Supreme Court in the 21st Amendment case. Now there was a question whether the Parliament has the right to form military courts through a constitutional amendment which would try civilians accused of terrorism. Now, as a democratic constitutionalist, it was a very, very difficult question to answer. On the one hand, the petitioners were saying that the Supreme Court should strike down a constitutional amendment passed by 2/3 of both houses of Parliament. Now, that is something that any constitutionalist grapples with. Why should judges get to strike down the will of Parliament, especially in a constitutional amendment? But the other issue was equally grave. Military courts. Now, military courts, it is said, are to the concept of justice that just like military bands are to the idea of music. They are an assault on the senses. Now, how can you reconcile the two? Now, predictably, the Supreme Court had 4 different views that came forward in that judgment. 17 judges heard it. Some of them went and said, 5 of them said that you cannot have military courts, and we are prepared to strike down a constitutional amendment in that. 3 of them said that no, Parliament's will must be respected, and we cannot strike down its constitutional amendment. 8 of them took a middle line. They said that we can perhaps strike down some constitutional amendments, but this case doesn't qualify so long as the Supreme Court retains the right of judicial review over any decision that the military court passes. So, and then there was a 4th view, and that was the view canvassed by Asma Jahangir Sahiba, and she took the line that which was accepted by Justice Afsar Saeed Khosa, and that was the position that although the Supreme Court cannot strike down a constitutional amendment, nonetheless there were technical defects in the amendments to the Army Act which made those military courts defective and inoperable. Now, these were attempts, genuine attempts, to grapple with a serious constitutional question. Now, that kind of dissent is very healthy. The second type of good conflict is when judges move on with the changing times. Now, in the US, jurisprudence. The classical example is Plessy versus Ferguson, where the US Supreme Court said that racial segregation is constitutional. And then much later in Brown versus Board of Education, they said no, racial segregation is unconstitutional. Courts should, the judiciary should move with the times, and they should grapple with these questions all the time. In our context, and I would differ respectfully with Mr. Irfan Qadir on that point, I think the Sindh High Court Bar Association judgment, to the extent that it laid to rest the previous doctrines of necessity and of supreme public welfare to justify military rule, the Supreme Court took a step forward. It was a conflict. It was a positive conflict. Similarly, when the Supreme Court today has struck down military courts, which earlier it had said trials of civilians in military courts is okay, when it took the step that no, it's not okay, FBLE was wrongly decided, I think that is a positive development. The problem is that you have to squarely confront the previous jurisprudence. The problem arises when the Supreme Court does not face up to the previous jurisprudence. It just ignores earlier judgments and chooses to render a new outcome in a different case. There it then just depends on the litigant and the judges at hand. And you have numerous examples of that. And I think Mr. Irfan Qadir has referred to several of those examples, so I won't bore you with those. Now, the way judges get around these conflicts is by simply pretending that they don't exist. They either ignore the earlier precedent or they call the earlier precedent distinguishable. Now, on a few rare occasions, earlier precedents are actually distinguishable on some principle of law or some distinguishing fact. But a lot of times, the distinguishing feature is merely different judges sitting on a bench, or a different litigant, or a different desired outcome. There is no actual distinguishing feature involved. It is, I'll just wrap up. The main point of distinction seems to be that in that case, the petitioner was wearing a red hat, and in this case, the petitioner is wearing a blue handkerchief. And then it really makes no difference to the result at all, to any kind of logic at all, but the outcome is completely changed. And so if you somehow land up with a litigant who is wearing a red handkerchief, you don't know whether he falls in the first category because it is red or in the second category because it is a handkerchief. Your result depends entirely on the mood and the whim of the judge concerned. So that is the kind of conflict which changes the rule of law into the rule of men. Now, what our judges must show is both discipline and courage. Discipline to follow precedents, even if they don't like the eventual outcome in the case. And courage that in case they genuinely consider an earlier precedent to be mistaken and outdated, then don't ignore it, don't distinguish it, face it and overrule it. Face all the legal issues involved and overrule it. Our Supreme Court has gone even to the extent, and Irfan Qadir Saab mentioned the Punjab Assembly case. In the Punjab Assembly case, the Supreme Court said that even if the issue was whether the votes of parliamentarians should be cast as per the direction of the party head, in a previous judgment they had said it must be cast per the directions of party heads. In the second case, they said, no, it has to be as per the parliamentary leader. And when pointed out that a larger bench had given a different decision, they said, well, if we unconsciously signed a judgment that was wrong, we can now consciously correct the same. Now, that is no logic. That is the issue that the Supreme Court must confront to end the conflict. Thank you very much.